Good morning. May it please the court, my name is CC Berman. I'm here today on behalf of the appellant Pathfinder. If I may, I'd like to reserve 5 minutes of my time for rebuttal, please. So we're here on this appeal because the trial court wrongly dismissed Pathfinder's foreclosure action with prejudice as to the appellees. And there were two arguments made that went toward dismissal below: statute of repose and statute of limitations. And if the court's interested, we'll just go ahead and address both. And I'll start with the statute of repose issue, which is the first issue handled in the briefs as well. Florida Statute of Repose is section 95.281 of the Florida statutes, and it says, if the final maturity date of an obligation secured by a mortgage is ascertainable from the face of the recorded mortgage, statute of repose is 5 years from the date of that obligation's maturity.
And that was ascertainable from the date, from the face of the mortgage, right?
Correct, Your Honor.
That part you're not arguing. You're arguing for an extension.
We're arguing for that it's a 20-year statute of repose, Your Honor, which is what happens when you have a final maturity date for a secured obligation, an obligation secured by the mortgage, and you can't find on the face of that recorded mortgage the maturity date for that secured obligation. In this case, we've got alleged defaults occurring in around 2006. I say around 2006 because the defaults are every time the developer, original borrower, transferred a unit to a purchaser or defendant without a release payment. That's the alleged default. Now, the foreclosure action is in 2013. So unquestionably, that action is more than 5 years after the alleged default. So the question becomes, is the statute of repose 5 years or is it 20 years? Now, the analysis, based on Florida law, based on the statute I just read, is really simple. One, what are the obligations secured by the mortgage? And two, is the maturity date of those obligations on the face of the mortgage? As an aside, it does not matter whether those secured obligations are recorded or unrecorded. In fact, the note in this case is unrecorded. All that matters is that the mortgage is recorded and whether that recorded mortgage says what the obligation's maturity dates are. So here, we've got a mortgage, it's recorded, it secures multiple obligations. It secures the note, it secures the loan agreement, it secures all of the collateral loan documents, in fact, it secures the modifications to the loan, and there's been no dispute about that, no dispute in the briefing about that. Now you can see plain and clearly the maturity date of the note on the face of the mortgage. There's a lot of talk about that in the trial court. It's right there. There's no dispute about that. But what you cannot see in that mortgage is the maturity date of the loan agreement. It is not on the face of the mortgage. The mortgage at page 636 of the record secures the loan agreement. It is a secured obligation, and nowhere on the face of that mortgage will you find the maturity date of the loan agreement. And thus the analysis becomes very simple. Because the mortgage secures the loan agreement and the loan agreement's maturity date is not on the face of the mortgage, the statute of repose is 20 years. Now, we could stop right there. We can also keep going and say, in fact, the Amador case came out, and it's a federal court case, and in this instance, Pathfinder had alleged in its amended complaint that the maturity date on the face on the note was incorrect, and the maturity date on the loan agreement, had it been on the face of the mortgage, it's a different date. And the effect of these different dates can't be decided on a motion to dismiss. Had the trial court accepted Pathfinder's argument as to what the correct maturity date was, then according to the Amador court, the maturity date would no longer be ascertainable from the record, and it would be a 20-year statute of repose.
Are you injecting the term loan agreement when the statute uses the term mortgage? The mortgage has a maturity date on it, and you're saying the loan agreement does not.
No, I don't think that's what I'm saying.
Okay, let me hear.
So it's not the mortgage itself that has a maturity date. The mortgage reflects the maturity date of whatever obligations that mortgage secures. And you can have a mortgage that secures different things. It can secure a note, a promissory note. It can secure a loan agreement. It can secure modifications to loan documents. That's what we have here. A pretty all-encompassing mortgage. So the maturity date you're looking for is the maturity date of the obligation.
And the note held the maturity date of November of 2006.
That's correct, John. That's correct.
Yeah,
okay, and that's on the face of the mortgage. That's one of our obligations. What I'm arguing is that we have additional obligations, additional relevant obligations that are also secured.
And those were not recorded?
Those are not on the face of the mortgage.
Counsel, I'm sorry.
Yes, Your Honor. I'm sorry.
assuming that the judge denied the motion to dismiss, wouldn't they still be able to raise the statute of limitations or repose as an affirmative defense?
Absolutely, Your Honor. Those are affirmative defenses. Well, and I say that. I mean, we've got a lot of folks
I'm not saying they could prove them, but they'd certainly be able to allege them and raise them and have them litigated.
Absolutely, absolutely. And in fact, you know, it's, for lack of a better term, to be a little colloquial, it's a bit dicey when you're using affirmative defenses as a basis for a motion to dismiss, which both statute of repose and statute of limitations are. Yes, folks could raise them. Now, in this instance, we have a lot of people who've already answered. We have a lot of other things going on. They're waivable affirmative defenses, but in short, Your Honor, yes.
Well, the statute of limitations was waived in the documents, right?
Correct, Your Honor.
So that's out.
Correct.
And those documents could have easily also been clarified to waive the statute of repose. That was not included in the waivers.
No, Your Honor, we are not arguing.
So you're stuck with the statute. Either the statute applies to your facts or they don't.
The statute of repose either...
The statute of repose.
Applies.
The statute of limitations is out. The statute of repose is really what's at issue.
Yes, Your Honor. Yes, Your Honor. And in a nutshell, I mean, I've really laid it out for you. You know, we've got multiple obligations. Are there maturity dates on the face of the loan? I mean, on the face of the recorded mortgage? The answer is no, they are not. And in fact, they don't even match up anyway. And it's as simple as that. It's a 20-year statute of repose. Are there any additional questions I can answer for the court on the statute of repose argument? No, okay. And so, likewise, on statute of limitations, I mean, Judge Valenti, you just hit the nail on the head. That's exactly the argument. It's a waivable affirmative defense. It was waived in the mortgage at page 640 of the record. Is binding on successors at page 644. There's no record evidence to the contrary. Had any been put in, that would have been outside of the four corners of the complaint anyway and inappropriate for a motion to dismiss. And if we're going to start getting into who took title when and how and subject to what, well then we really can't do that on a motion to dismiss. The only legal argument that's been given has to do with a statute, arguing that the statute 95.03 prohibits contracts that shorten statutes of limitations. Well, that's not what we're arguing here. So the statute of limitations issue is a non-starter in that it should not have been a basis for dismissal. Are there any questions I can answer on the statute of limitations argument? No. That's really all I've got. Are there any other questions that I can answer?
Well, can you maybe hit on the case of Zlinkoff versus von Oldenbroek?
I'm sorry. Oh, I'm talking the Zlinkoff case?
Yes.
Von Oldenbroek. Okay, yes. So the Zlinkoff case is a case about extensions and extending maturity dates, which we don't have here. I mean, here, these two different maturity dates, they existed from day one. So clearly they weren't an extension. It's not like Zlinkoff, where we have a 1992 maturity date, and then that date keeps getting orally extended year after year after year after year.
How many dates were ascertainable on the face of the mortgage, maturity dates?
One.
And that was at November?
Correct, Your Honor.
6th date.
Correct, Your Honor.
So the other date is not ascertainable on the face of the mortgage.
That's correct, Your Honor. And do you know what, Your Honor? Even if they've been the same date, it's still, our argument was still...
They were not recorded.
None of the secured obligations were recorded.
Aren't those required to be recorded to create the ambiguity so you kick in a 20-year extension?
No, Your Honor, absolutely not. In the Layton case, the Hook case, those involve unrecorded obligations where the recorded mortgage is securing those unrecorded obligations. And in those cases, you've got, I just don't want to misspeak. I want to tell you they're both 20-year statutes. Yeah, Layton's a 20-year statute of repose, and so was Hook. Now in Hook, it ended up being barred by statute of limitations in that case that had been raised differently, but statute of repose had not expired in either of those cases after 5 years. So they were both 20 years. Both based on unrecorded secured obligations. Have I answered your question, Judge Valenti?
Yes, I appreciate that. Thank you.
Okay. Anything else that I can offer the panel? Okay.
Thank you.
Thank you.
Good morning. May it please the court, my name is Michelle Cavallero with Fidelity National Law Group, and I represent 6 of the appellees in this case that we've been referring to as the Thibault defendants. They all raise the same motion to dismiss in this case and argued the same motion to dismiss.
Counsel,
Yes,
ever
sir.
since I can remember, the law has been that in considering a motion to dismiss, the trial judge simply looks within the four corners of the complaint to determine whether it states the cause of action. That's been the law for as long as I can remember anyway. Has that changed at all?
No, Your Honor, I agree.
If you look within the four corners of this complaint, I think they've stated a cause of action. But comment about my other question here, you could raise the things you're raising as an affirmative defense in your answer. So it seems to me like you're being premature in getting a dismissal of this case on the arguments that have been made.
Well, I disagree in this sense that, yes, you can't go beyond the four corners of the complaint, but that includes attachments to the complaint, which in this case included the mortgage and the loan documents and the note. From that and from the allegations in the complaint, we could either have filed, an answer with affirmative defenses and the statute of limitations and the statute of repose, or we could have moved to dismiss if it was obvious from the face of the complaint and from the attachments to that complaint that there was no way that a claim could be stated. And that's the case here, Your Honor. The case that no matter what iteration the complaint went through and no matter how many amendments the plaintiff went through, the fact of the matter is they were never going to get around the 5-year repose period, and they were never going to get past the 5-year limitation period. Because
But wasn't that waived? The statute of limitations was waived in the documentation.
I disagree, Your Honor. Was it waived by the borrowers under the note and mortgage? It appears that way. Was it waived by the appellees in this case, my clients? Absolutely not. They were not a party to that mortgage. They weren't a party to the provisions of that mortgage. They're not subject to it unless under the case law they specifically took title subject to the mortgage. They did not do that.
Counsel, that makes my point. Those are things that have to be litigated after you plead your affirmative defenses and everything. You don't litigate them by a motion to dismiss.
Well, Your Honor, I would point to, and these are not cases I cited actually, they were cited by the appellant. The Amador case and the Green case, they were both cited in appellee's initial brief. In both of those cases, Your Honor, the court dismissed the claims based on statute of limitations and statute of repose that also could have been brought as affirmative defenses. And in those two cases, Judge, I'd even point out that the court pointed out, as I think the appellant just noted, that there was an ambiguity even in the pleading of both of those complaints, where there was a question as to which date the plaintiff was proceeding under. And what the court said in both of those cases is, it doesn't matter which date, because under both dates, they're beyond the statute of limitations or the statute of repose.
Would you concede that if you divorced yourself from the issue of the statute of limitations and all that the claim or the complaint stated a cause of action?
If we
divorce the issue of statute of limitations and the statute of repose, that it states a cause of action?
I suppose if you put both of those issues to the side, but then, and I was going to point this out later in my argument, that this is strictly a mortgage foreclosure action. It's only to foreclose the lien. It is not, for instance, an action on the note as well. It's not for breach of the loan agreement that was mentioned. It's not for breach of the note. It's strictly to foreclose the lien. So, Your Honor, I don't know if you can divorce those two issues, because with the statute of repose and statute of limitations, there is no lien, and therefore there's nothing to foreclose, so there's no cause of action. And that's why it was brought forth as a motion to dismiss, because of the futility. And that's what, for instance, the Amador and the Green case discuss, is that if it would be futile to continue to amend the complaints, then it's appropriate in the motion to dismiss, and it's appropriate for the trial court not only to grant the motion to dismiss, but grant it with prejudice, because it would just be an exercise in futility to keep amending this complaint. There is no amendment that would save it from both of those statutes. and their operation.
Well, I mean, that wouldn't be true on the statute of limitations, only on the statute of repose.
I would argue under both, Your Honor.
Okay, but let's talk about the statute of repose, because opposing counsel cited Layton. But Layton contained a mortgage that didn't have a maturity date and a promissory note that did.
That's correct, Your Honor. Layton, out of this district, was held to be under the 20...
And the note was not recorded.
Correct, Your Honor.
Layton, you have a case where maybe there was an extension that wasn't recorded that still wouldn't affect the statute of repose, but your mortgage was recorded and it does have an ascertainable maturity date.
Correct, Your Honor.
So tell me why does Layton even apply to your facts?
The Layton case and the I think I'm pronouncing this right, Hope case out of this district, they both have situations where the mortgage was recorded but did not have a maturity date on it. The note was unrecorded and had the maturity date.
And that fits squarely within the statute for the 20-year statute of repose.
Exactly, I agree. And I would say further than that, if this were a case where, in this case, if the mortgage had, as it did, the mortgage stated the maturity date of the note in it and the mortgage was recorded. If in that mortgage it also, let's say, attached the note and the note was recorded with the mortgage, like it was in American Bankers and like it was in the Razak case, and Razak's out of this district as well. In those cases, then you're looking at the 5-year statute because the mortgage that was recorded referenced and included the note, and the note had an ascertainable maturity date. Right. So those two cases apply to this. And further, I would argue that if it were a case where the mortgage referred to the maturity date of the note as X, and then the note was attached and recorded and referred to it as Y, that, I think, is the only situation where you would have a recorded document in the public records where you would have an ambiguity that the appellant is trying to talk about. You would have then an ambiguity because you have a recorded mortgage that says one maturity date and you have a recorded note with the mortgage that has another one. In that case, I think the appellant would have a better argument to say, look, it's unascertainable because we don't know which maturity date is correct and they're both recorded in the public records. And that's the key.
Even if you're on notice that there may be an extension agreement that's not recorded, that doesn't provide an extension because you're in charge with notice in the statute. You have to record that unrecorded document to get the extension under Zlinkoff, as I read it. Is that correct?
That's correct, Your Honor. And as a matter of fact, I was going to point out the Zlinkoff case in that that's exactly what that case said. The court held there's nothing in the statute, meaning 95.281, that suggests a duty to investigate beneath the public records or provides an exception for, a party having notice. There's nothing in the statute, and the plain meaning of the statute is, if you look behind the statute itself and you look, first of all, why is this statute important and they enacted it? It's because, number one, the general overall goal, obviously, is to bring a termination at some point to lawsuits, and that's the goal of every statute of limitation in the statute of repose. There has to be an end at some point. And then, specifically...
Well, this is a preemptive strike. The statute of repose basically takes away the document of having any legal effect where you can't even... It's still like it doesn't exist. You can't sue on something that doesn't exist. So it evaporates by operation of law, unlike a statute of limitations, which is basically an affirmative defense to enforcement.
I agree, Your Honor. Okay. And I agree that I think the reason behind it is because not only are you looking at something like a limitations issue where you need finality to judgment, you need finality to lawsuits, but also in this case, it specifically talks about the repose in terms of mortgage liens because of the fact that mortgages involve real property and real property involves frequent transfers and sales. And because there are different parties involved and because the general public, meaning third parties...
I mean, what you had here was a master condo conversion mortgage. Is that correct? People would pay the developer as they go to pay off, to get a partial release of that master condo conversion mortgage so they could satisfy their bank. And apparently somewhere along the line, developers taking in the money and not getting the releases, but yet the statute of repose has expired to cover those mismanagement of funds, so to speak.
That's...
And there's a bunch of other
yes.
cases pending below that this would ostensibly affect. There's 6 cases on appeal, but there's a bunch of other cases in the pipeline. How many cases are filed below or potentially possible in this area?
Oh, I believe in this specific instance with this developer, this is it.
Oh, it's just these 6? Okay.
I believe, no, this developer in the lawsuit itself actually mentioned, and my co-counsel will address the other appellees,
Okay.
but they named everybody that they could possibly name, everyone who took title to one of the units and paid it off. But evidently did not get, the partial release was given, but evidently the plaintiff is claiming that they never got the funds.
Right.
So, yes. But I think going back to the reason for the statute of repose, I think that, and you make my point, that with real property, it becomes so complicated because of the different transfers, because of the frequent sales, that it's very important to have a third party, which is why we have recording statutes, to be able to look at the public records and know what the status of the lien is, what the status of the property is. And that's, I think, when you look at that reason for the statute of repose, it makes sense then that the statute, when it talks about whether it's a 5-year term or a 20-year term, talks about the recorded obligation and whether it's obvious from its face of the record. And that's important because the legislature could have used other words. The legislature could have said, if it's obvious from the loan documents, if it's obvious from the face of the document itself. But the legislature didn't use that word. They specifically used the word face of the record of it, stating basically that it has to be recorded. And why is that important? Because this way third parties and innocent parties can look at the public records and ascertain whether or not a mortgage lien is valid or not just by examining the public records. And the whole point of that is they don't have to go behind the scenes. They don't have to play detective and dig around and look for documents. If this were not the case, then we can see where this would go, because you would have to track down a loan agreement and every document regarding that loan and examine it. It makes no sense.
That's on the statute of repose. I think I misspoke about the statute of limitations. Statute of repose, what I was thinking would trump the statute of limitations, would moot that out. But the statute of limitations, if that defense is available, is not clearly ascertainable from the 4 corners of the record, because each payment that's defaulted would bring a new statute of limitations, period. So the complaint was filed, let's say, in December of 2011, you'd have to count 5 years forward, and you're well within a statute of limitations, so that could be a viable defense. But it's moot if the defense is wiped out under the statute of repose, is what I was driving at earlier. Is that true or false?
I agree partly. I think in this case...
You said you wouldn't concede the statute of limitations, and I'm just wondering, does it really matter in your instance if you went on the statute of repose? You don't have to worry about that.
Correct, Judge.
And why wouldn't you concede the statute of limitations again?
Because I think in this case, and there are cases actually to talk about this, and I think it's actually the Razak case does discuss this, that sometimes you do have a particular instance where, because of the maturity date being spelled out, that you actually have a situation where the statute of limitations dovetails with the statute of repose.
Well, we don't have that here.
Oh, I think we do. I think we do, Judge, because, and I agree with the court.
Didn't they agree to an extension until December of 2011? I'm trying to remember
no,
exactly
Your
the
Honor.
date.
Even if you look at that as an extension, it's an extension for 1 month. It goes from November of 2006
to December 2000. Okay.
Yes, Your Honor. So it would only be extension of a month.
To December 16, 2011.
Correct. So even assuming...
So you're saying that would relate back to November 30, 2006?
Yes, so in the light most favorable, they still are way past the 5-year limitations period. And if you count into, as the court was pointing out, the fact that each payment triggers a new limitations period, the maturity date is the end game. The maturity date is the absolute last date that their final payment is due. And you count forward from that 5 years, even given this if they could argue.
But you'd win on
December date.
on the estoppel argument, that the statute of limitations is waived in the documents?
Well, and that's
That's my other question.
And that was my final point, was as to waiver, that first of all, the waiver provision could only apply to my clients if they were a party to that mortgage, which they clearly are not. And I don't think there's been any assertion in the complaint or otherwise that they were parties to it. The assertion was that they succeeded, their successors in interest under the mortgage. But actually I would say that's an opposite, actually, because my whole argument from day one has been that my clients did not take subject to the mortgage. That mortgage was already invalid, the mortgage lien was gone.
I just want to let you know it was 15 minutes.
Counsel, I have one last question. Was this dismissal with prejudice or without prejudice?
This was with prejudice, Your Honor. And I
You're not gonna
believe,
give- Okay.
I believe the trial court decided that it would be futile to continue to allow them to amend, and rightfully granted the motion with prejudice, and I would ask that this court affirm.
Thank you.
Thank you.
Martin Auerbach, I'm here on behalf of the additional appellees that were not represented by Ms. Cavallero. Our clients filed, and some of the other clients, I'm speaking on behalf of clients that are also represented by other counsel due to time limitations, but we actually filed answer and affirmative defense, and but the way that the order is written, if the court were to affirm on the statute of repose, it would be applicable to all of the parties, because what the ruling was that the first amended complaint is hereby dismissed with prejudice as time barred. And the statute of repose, as was being addressed before, that would apply even if there weren't a default. It supersedes, and Your Honor is correct, that if you were to affirm on statute of repose, the statute of limitations becomes irrelevant to...
Is there anyone left below that the statute of limitations argument might be relevant?
No, it would apply, it either applies or it doesn't apply to everybody. These are all subsequent purchasers, and although the complaint carefully avoids any dates for any of these things, doesn't even say the date that the interest is accruing from, they just give a total amount. But the sole basis, if it were to be affirmed on statute of limitations, would be that it's apparent from the face of the pleadings that the maturity occurred in November of 2006, and as counsel pointed out, even if you were to go by that correction that they call it, that only added, I think, 16 days to the date. So it would still have been time barred. But the statute of repose is just, as court pointed out, is just applies to terminate an action. It doesn't matter if there's been no default. It doesn't matter if there are defenses or if the cause of action is even accrued. And that's carefully discussed in the Hauk case that's cited in the briefs. Also, to address one of the other arguments that was made by appellant, the distinction, or the attempted distinction between correcting an error versus an extension agreement, that was actually addressed by the Irwin versus Grogan Cole case, where they had tried to argue that if you looked at the mortgage, you would have seen that there was an error. If you had run an amortization table, basically, you would have seen there was an error in the maturity date, and the court said, no, you just go by the date in the document. You're not required to do some sort of investigation or to determine whether the date makes sense. And then another point I'd like to address is on the statute of limitations. The mortgage purports to prospectively waive it. Waiver would be something that you have to show that there was a knowing, conscious, I mean, waiver is a high standard, but it's, and importantly, what it says in the mortgage is to the extent permitted by law. So now...
Well, I mean, the mortgage was not assigned to each individual buyer, but they took subject to the mortgage.
Well, not subject to in the way the case is discussed.
Well, that's why would they need a partial release if the mortgage didn't cover the property they were buying?
Yeah, if the mortgage was still valid, it was an encumbrance on the property just based upon the Recording Act. But there's the Irwin case, which discusses taking subject to, where the party actually took subject to, versus I think it was the Zlinkoff case, where they made the distinction, said, well, just because the mortgage was on there when the property was purchased doesn't mean they took subject to. Subject to means in your deed it says subject to as opposed to assumed by the party. And Zlinkoff makes that distinction between just buying subject to versus taking title subject to. And one of the things that's ironic about all this is in the trial transcript, counsel for the appellant actually asked the judge to, if he ruled in the plaintiff's favor on statute of repose, could he make it just applicable to everybody so he wouldn't have to come back in and re-argue it against other parties. Unfortunately, for plaintiff, the judge went the other way, and I guess counsel didn't ask him to make it universal then, but it would seem to follow that if it is universal, it applies regardless of the finding. And so,
Just wanted to let you know you'll need to wrap up.
Okay, thank you, Your Honor. In conclusion, it's just apparent on the face, and the argument that the loan agreement might have a separate life of its own doesn't make sense, just from the standpoint that if nothing is owed, you can't have an obligation to keep the lender named as an insured or do other things. Either there's a debt or there isn't a debt, and if the debt's been extinguished, then the mortgage is extinguished. Thank you.
Thank you.
Thank you. A lot of what we just talked about all dealt with an entire argument based on the premise that we have one secured obligation, the note. We have two. Now, we just heard that the idea that the loan agreement is standalone makes no sense, but on page 574 of the record, which is in the amended complaint, it talks about all amounts due and owing under the loan documents. That would be the loan agreement, the note, all of the usual suspects, if you will. And the loan agreement is a secured obligation, and its maturity date isn't on the face of the mortgage, and no one has suggested so far that it is. And that fact alone is enough to render this a 20-year statute of repose. We talked about Leighton a little bit. Why, and Judge Blanty, you asked, why does this fit within Leighton? Because Leighton involved a recorded mortgage and an unrecorded note, yes. This is the same thing, it's just the loan agreement is the secured...
The maturity date.
That's correct, but
That's a
remember
big
here we
difference,
have...
isn't there?
Absolutely, but here we're still missing a maturity date, just like in Leighton. We've got a maturity date on the note, but just like Leighton, we have another obligation that's secured, the loan agreement, and we don't have a maturity date on the
The other
note.
documents aren't recorded, only the mortgage is recorded.
That's correct, and that's exactly how it was in Leighton.
That's what the statute talks about, isn't it?
I think I'm not following, because I think it's, under the statute, it's all that has to be recorded is the mortgage. These other obligations the mortgage secures do not have to be recorded.
Okay.
And the note's not recorded in Leighton. The note's not recorded in this case. Nothing is recorded in this case,
But
other than the mortgage.
you haven't given me one case where the mortgage is recorded and the mortgage has a ascertainable date on the face of it and the 5-year statute doesn't apply. There's not one case that
Because
says
I'm
that.
arguing, Your Honor, that it's not ascertainable on the face of our mortgage.
But there's no case that exists where the mortgage date is ascertainable on the face of the mortgage, the maturity date, and then you drop down to the 20-year extension. There's not a case out there that
That would
does
be
that.
absolutely correct, because that would, yes, that would defy the statute. If the maturity date's on the face of the mortgage, it's 5-year statute of repose. We have no argument there. What I'm saying is There's not just one, it's not just the maturity date. The statute says the maturity date of the obligations secured by the mortgage.
Okay.
And we have more
You're
than
reading
one
obligation
obligation.
as more expansive than just the mortgage.
Correct, Your Honor. I'm saying if you look at the mortgage even expressly says, it goes on to say, it secures these other obligations. The
But then,
mortgage.
see, what I'm hearing is, then everybody would have to look at all these other documents to determine the maturity date of the mortgage, even if the mortgage references.
No, I agree with you.
A nightmare for.
No, I agree. There's absolutely no duty to dig into it. I agree with that. That's what this Linkoff case says. We are not suggesting anyone has a duty to do that here. But you could look at this mortgage and you could see that other things are secured by it. And you would see that there's no maturity date, just like other cases where the maturity date's not on the face of the mortgage. I think Judge Kelly, did you have a question?
No.
Oh, okay. Okay. And I was going to say about Linkoff, and we talked about Linkoff, and here we don't have an extension. An extension would be I have a set maturity date on an obligation, and then I ask you, if you're my lender, to keep extending that date. In this instance, we have just different dates from the get-go. So there was never an extension. It's even under 30 days, this difference. It was just a mistake, apparently, when they executed the loan documents originally. So anyway, I wanted to make those distinctions a bit. We talked a little bit about statute of limitations and the waiver issue. And all I wanted to mention on that is either, as the counsel just mentioned before me, it's all about what's in the deeds and all this other extraneous outside the four corners of the complaint evidence, in which case we can't be here on a motion to dismiss, as you pointed out, Judge Ployce, or you take subject to the mortgage, and in fact, this Linkoff case does suggest you take subject. If the statute of repose has not expired when you take title, as Linkoff suggests on pages 842 rolling into 843 of the case, it suggests that if you take title and the statute of repose has not expired yet, you are taking title subject to the mortgage. And there's no debate here that when everyone took title, the statute of repose had not expired. And that is what Linkoff is saying. So in fact, it's quite arguable, it sounds like to me, even not going into the deeds and everything else, that everyone did take title subject to the mortgage and the waiver provision would apply. The last question I want to move over to is the other appellees. And you had asked about this, Judge Valenti. We talked about what's going on below and whether everything in the statute of repose applies to everyone. That's a waivable affirmative defense. It may extinguish a lien, but you don't get lucky enough if there are, multiple defendants and one person asserts it and everyone else keeps on trucking. The other four don't take sort of the benefit as to that one. It's a waivable affirmative defense, and we have a lot of folks here who've never raised that affirmative defense, ever. And we have a lot of people who aren't even here today. We've got folks who have adopted a substantive answer brief that includes, we only have two issues here, repose and limitations, both waivable affirmative defenses. We've got folks adopting who never raised both, but they're adopting the arguments that they raise both, which cannot be a basis for affirmance.
What's your best case that says it's waivable, the statute of repose?
The Johnston case, 32 Southern 3rd, 700.
Okay.
So that cannot be the case. I mean, even counsel who is up here representing the 6 appellees who are the true appellees.
Left below, for the people here today.
For the people here, there are people here who adopted there's one entity that filed its very first pleading ever in this case, in this appeal, adopting. Never filed anything in the trial court. Then 17 of the folks adopting, they filed answers below. They did not file motions to dismiss. And we're here on a motion to dismiss. And then of those folks who answered, I can tell you that none of them raised the statute of limitations. Some folks, on the other hand, who did adopt raised statute of repose. And as counsel for the 6 true the briefs show that we've got 6.
Was this argument made below that it was waivable? I didn't see that being the issue on appeal.
Well, I'm sorry, it's not. It became an issue when all these adoptions of the answer brief rolled in unexpectedly.
Okay.
Because they were adopting arguments that had never been made or taking positions that these were folks who had answered the complaint before, and suddenly they were adopting an appellate brief of a party that got out on a dismissal and potentially on an issue that they never raised, which was a waivable.
They're raising an issue on appeal that they never raised in the trial court.
Absolutely.
So they can't
Absolutely.
raise that
And we've
here.
got fact issues we've talked about in this case that Pathfinder has a right to test as to all of the defendants. So that would just be completely inappropriate. And we still have defendants still down there. The counsel representing the 6 true appellees that the briefs acknowledge, the substantive briefs filed in this case acknowledge are the appellees, represents other folks still below that are not notably on the face of the brief. And that's because it's just a bit of chaos, frankly, the way it's unfolding here. So it does matter, and it is prejudicial, and there is a right on these issues for Pathfinder to be heard one by one. Are there any other questions I can answer?
No. Thank you.
Thank you.
Thank you.